First to speak to us tonight is Hall Bryant III. He has recently come to Huntsville. He's with Bradley Arant, which is, I guess, Alabama's largest law firm, still Alabama's largest law firm, but he was in Birmingham for a number of years before he came to Huntsville. He's originally from Huntsville. I've known his daddy for a long time, and I've known his mother as long as they've been married. They're a super family. I tell you, that's one of the delights of practicing law in Huntsville, Alabama, that you know a lot of these people, and you know their mamas and their daddies and their grandparents, and it's a nice way to live your life and a nice way to do business. But Hall attended Birmingham Southern, where he was a member of Phi Beta Kappa, and he graduated magna cum laude. He got his law degree from Vanderbilt University in 1992, and was appointed to the Order of the Coif, which is a legal honorary society. He received the American Jurisprudence Award at Vanderbilt for real property and conflicts of law, and currently he is a member of the Alabama Bar Association and the American Bar Association, and he limits his practice to corporate and securities work. And tonight he's going to talk to us on corporate work, as I understand it. I'd like to introduce Hall Bryant III.
How you doing? As George mentioned, I primarily concentrate my practice in the area of corporations. I'd like to just let you know a little bit of what I do before we get into the topic, which is going to be corporations, for a number of reasons. One is to convince my family that I don't get into a courtroom very often, and because every time we're at the dinner table and there's some discussion concerning the O.J. Simpson trial or whatever, something that's legal point from a courtroom at the dinner table, everybody turns to me and expects me to explain why a certain piece of evidence didn't get into the courtroom. I don't deal in that kind of law. I represent people that want to incorporate a business. I represent people that want to dissolve a business. I represent people that want to purchase a business or sell a business. I also help people and corporations in terms of issuing stock and securities. These range from small mom and pop operations up to large corporations that are publicly traded. Today, in that realm, when most people think of corporations, they do think the first thing that comes to mind is the large multinational corporation that has the 2,000, 5,000 shareholders. But the vast majority of corporations in the United States are small, solely owned or owned by a couple of people. It could be the local grocery store, it could be the cleaners down the road. Those are all corporations, and so when you hear the term corporations, keep that in mind. In terms of my discussion today, I'm going to talk about four main topics, and hopefully this will give you a good overview of corporate law. The first one is I'm going to talk about why to incorporate. People usually come in to me and they ask me that question, why should I incorporate? And I hope I'll give you the same type of answers as I give the people that come into my office. The second topic is I'm going to discuss about formation documents. I'm just going to give you a brief overview of the type of documents that go into incorporating and putting together a business. The third topic is more of an operational and formational issues. I'm going to tell you a little bit about how to finance a company and how to issue some stock. And the fourth item I'm going to talk about is protecting the corporate entity, and that is if you are a shareholder of a small corporation, you want to avoid any liability from your personal standpoint. You want to limit your liability associated with the company to your investment that you actually placed in the company, and I'm going to give some tips on that. And somewhere in this, I'm going to tell you a little bit about if you do want to incorporate, maybe the fees that you will incur, legal fees and other filing costs, as well as ways to reduce those costs that you may incur. Before going into those four main topics, I'd just like to run through very briefly the general terminology associated with corporations. I think most of you are probably going to be familiar with it, but I just want to make sure. The first one is, what is a corporation? A corporation is an artificial being, and it's a separate legal person distinct from the persons that own and manage the company. In general, the corporation is not affected by the liabilities or obligations of those that own and manage the corporation, and likewise, the people that own and manage the corporation are generally not affected by the liabilities of the corporation. Second term, shareholders. That is the owners of the company. They're sometimes referred to as stockholders. The next term is the board of directors of the company. That is a group of people that oversee the general business affairs of the corporation. The directors are elected by the shareholders each year at an annual meeting. And specifically, the board of directors basically sets the policies of the company, and it also is required in the Alabama Business Corporation Act to act in certain situations, such as in order for a corporation to declare dividends, the board of directors must meet and authorize that declaration. Also, the board of directors generally authorizes the corporation to borrow money and to mortgage its assets in connection with such borrowings, and authorizes the issuance of stock. Probably one of the most important duties of the board of directors is they elect the officers of the company each year at the annual meeting of the board of directors. And that brings me to the next term, is officers. Officers are the people that run the day-to-day operations of the company. Each corporation must have at least a president and a secretary. Most also have a treasurer and probably numerous vice presidents and other officers that they come up with their own specific titles. They decide on how the policies that the board sets are going to be carried out in the day-to-day administration. They decide on who they're going to hire and who they're going to fire in terms of their line employees. They probably will go to the board in order to determine if it's some key manager of the company. They'll probably want to get kind of the backing of the board of directors and get them on board in a situation like that. They also execute documents on behalf of the company. The shareholders and the board of directors do not execute any documents in that capacity. It's merely the officers of the company or someone else specifically designated by the board of directors to sign those documents. Let me go over those four terms just to put them in order. If you think of this as a pyramid, at the top you have the shareholders. And the shareholders make certain decisions. There's certain things under the Alabama Business Corporation Act that they must do, but most importantly is that in terms of their share, is they elect the board of directors. So the shareholders control the board of directors. They have the right to remove them and to elect them. And in turn, the board of directors sets the overall policies of the company, and they elect the officers. So the board of directors elects the officers, and the officers run the company. So if you control the vast majority of the shares of the corporation, you control all the way down to the bottom line of the company, because if you don't like something there, then you can turn around and replace the board of directors with your own people, and then in turn, the board of directors can replace the officers with the people that you have designated. So it's very important if you're going into a business venture that you really consider the number of shares that you own in that business venture so that you may have some kind of controlling interest over the board of directors. Two more terms. Dividends. Dividends is merely distributions of cash or other property to shareholders. Usually they come out of the income of the company, but most closely held corporations retain part, if not all, of their earnings and plow those back into the company and don't distribute them all out to the shareholders. The next term is just stock, shares of stock. That's your ownership interest in the company. It's just a certificate that says the number of shares that you own, the corporation's name, signed by the president and signed by the secretary. If you have any stock certificates in your possession from any company, even if it's a closely held company, you need to keep those in a safe place because they are similar to a vehicle, certificate of title for automobiles or a deed for real property. They are what actually reflects what you own in that corporation. Now I'm going to get to the main topics now, but the first one is the initial formation. And when somebody comes to me and they ask, you know, I have this idea, my buddy and I are going to go into a business venture, we're going to start a carpet cleaning company. And you know, we've heard about it, and we're going to put some money in, and we're going to put some equipment into this business venture, but we've heard about this incorporation thing. You know, tell me something about it. Why should I do it? There's probably 4 main reasons why you should consider incorporation. First and foremost is limited liability. Second is the continuity of life. Third is centralized management. And 4 is free transferability of the shares. Let me go through each one of those. Limited liability. This is the most important reason why you want to incorporate your business. In general, the owners, and I'll explain that in general part, the owners of the entity will not be personally liable for the debts, obligations, and claims of the corporation. Let's use a big example just to go through it. General Motors. There may be people in here that own General Motors stock. If General Motors incurs some substantial liability tomorrow and all of a sudden goes bankrupt, you would not expect the creditors to show up at your doorstep wanting you to pay back additional money. The only money that you have at risk, or that you expect to have at risk, is the amount of money that you put in the company. There are a couple exceptions to that, and I'll run through those briefly, and if we have time, I'll discuss them in greater detail. The first is that you're always going to be liable, no matter what, for your own acts or conduct. Let's take the carpet cleaning example. Somebody starts a carpet cleaning business. They go out to and clean some carpets. They send an employee out there. The employee knocks over a $50,000 base. They've done a good job in hiring and training the employee. There was no negligence on part of the shareholders of that corporation. In that instance, then, and say the corporation only has $10,000 in assets. If there's a suit brought against the company and a judgment rendered for $50,000, well, the $10,000 of the corporation's assets should go to pay that obligation, and that it should stop. The company should be liquidated, put into bankruptcy, that's it. But say I am the owner of that corporation, I'm also an employee and an officer, and I go to the house and I'm dancing around and I knock over the vase. The corporation in that instance, and me personally, my house, my bank account, everything else is subject to be attacked because I have personally acted in that situation. So you just keep in mind that you're still liable for your own acts or conduct. Also, you can be liable for corporate veil-piercing theories. What that means is that in a situation, if you do not respect the corporate form, courts will not respect the corporate form. And to explain that, they look at a number of factors, one of which is undercapitalization. If you form a corporation and you don't put enough money in there to meet the ordinary obligations of the company that arise from time to time, then the court's going to view that as merely a sham, and it's probably going to look at some other factors in doing that in an attempt to avoid liability. Example, if I'm in the environmental waste disposal business and I start a company and I put $100 in this company, and I don't go out and get insurance or anything else, and then I dump the solid waste on my property and hide it back there, well, I'm probably going to be liable there for my own acts of conduct. But also, I really haven't capitalized that company in order to meet those liabilities that arise from time to time. Another problem that people get into, and that you can get through the corporate veil, is when you commingle funds. You need to respect the company. You keep your funds over here. You have a bank account, books and records for your company. Don't pull your money out and put your money in and out of the corporation. Don't use it as your own personal pocketbook. And another item is failure to hold your annual meetings and other major meetings that corporations are required to have. In Alabama, you're required to have at least an annual meeting of the shareholders and an annual meeting of the directors each year, and the shareholders to elect the directors, the officers and the directors elect the officers. And in those meetings, you also need to hold meetings from time to time for other large events of the corporation that I kind of briefly went over earlier. The third item where you get around the limited liability situation is a personal guarantee. And a lot of you may think, well, a personal guarantee, well, everybody knows that. I was assisting somebody not too long ago in putting together a corporation, and they said, now, when I put this corporation together, I'm going to go borrow some money. I'm not going to be liable for that. Well, technically, if the corporation borrows it, that's the truth. But these individuals did not understand that the bank does not want to be in their business. The bank is in the business of lending money and getting paid back. So the bank is going to look at that business and going to ask, can I get my money out of this if everything goes wrong? And in most startup ventures, the bank can't. The bank does not want to be in the carpet cleaning business, so it's going to require a personal guarantee out of you. It's going to require, generally, you to put your house up or whatever collateral that you can come up with to assure it that it's going to be paid back. The other ones I can run through very briefly. That was the most important reason on why to incorporate. Second one is continuity of life. Continuity of life means that when the owners of the company or the managers of the company die, declare bankruptcy, become disabled, that the corporation continues. It's out there. It's a separate legal entity, distinct from those other members, the owners and the managers. So that's a benefit. It just passes along to your heirs. Centralized management is another reason. It has a set formula like I went through, and it's something that's easily used. There's not a whole lot of complicated mishmash to it, so it's something already there that the corporate code puts out. Free transferability, this is an advantage and a disadvantage. If I'm in a corporation subject to some kind of restriction on transferability of stock associated with some securities laws out there, and there's two of us in a corporation, I decide I don't want to be an owner of this company again, I can go to Alan Brinkley and say, Alan, I want to transfer the stock to you for X number of dollars, and if he wants to get in, he can buy my stock and move on. A lot of people don't like that, so they come up with what's called a buy-sell agreement, and I'll get to that in a second. Let me run briefly through some alternatives to incorporation just so you can hear them. One is a general partnership. That's just an association of two or more people that are in a common enterprise for a profit. If the two individuals that came to me about the carpet cleaning business decided they didn't want to incorporate and they just went out and started running this business, they would be deemed to have a partnership. The problem with a general partnership is that each partner is personally liable, jointly and severally with the other guy, for every act, obligation, liability of that partnership, and of the other partner when he takes actions in connection with that partnership. So that's not really a wise thing to do there. There's also extensive limitations on transferability. You can't have new partners without getting the consent of the other of the partners. And if you want an agreement, it gets relatively complicated and expensive. The limited liability company is a new venture that's out there that a lot of people are getting excited about, and it's kind of like a general partnership except it has limited liability. A lot of my clients don't want to use that unless they're going into a real estate venture from the outset for two main reasons. One, it's generally more expensive than the formation of a corporation, and they can get a lot of the benefits of the things they want to get out of it through a corporation. And the second is that it's relatively new. Nobody knows how great the liability shield is. It should be good, but it hasn't been tested in the courts. Another item is the limited partnership, which is similar to a general partnership. In a limited partnership, you have a general partner that's liable and a limited partner that's not. But the limited partner has no management rights, and that's a disadvantage for the limited partner because he's basically sitting out there waiting for somebody, hoping that the general partner will operate the business in such a way that income will come in, and he can't take over the management very well. A couple other points I just want to say in terms of the formation and the decision-making that I kind of jumped over, and just to let you know, there are two types of corporations, a C corporation and an S corporation. This is usually the major decision that somebody makes when they come to me. And we usually make this decision with an accountant. We get an accountant involved because the accountant's going to be doing the day-to-day operations, doing the books every year and other items. But just to give you a quick thumbnail sketch of a C corporation versus an S corporation, is the only difference is the federal and the state tax laws. There's no difference from state corporate law. So it's the same entity, it's just a document that's got to be filed with the Internal Revenue Service. A C corporation has double taxation. That means that if the corporation earns $100 in year one and the tax rate's 40%, that the corporation pays $40 to the government. If it distributes the money out, the $60 that's left to the shareholders again pay taxes on it, say 40%, $16, so they end up with about $44. There's a way to avoid that in closely held companies by tying the amount of your salary. If you're the shareholder and an officer or employee of the company, you can tie your salary generally to somewhat equal what you expect the income of the company to be. So if you have the company has $100 in income, it pays out in salary $100 to the individual. The company gets a deduction, so the company has zero tax. The individual just has his tax out there at the 40% level, and he gets $60 instead of $44. Now, an S corporation is different in that everything passes through to the shareholders. There's no tax in general on the corporation. The corporation merely files an informational tax return. So if there's $100 in the corporation in income in the first year, and then that income is attributable to the shareholders. So the shareholders paid the tax on it. They pay the $40 in tax. There's $60 left on it. They can leave it in the corporation, or they can distribute it out, or they can just wait and distribute it out later. So, but they can leave it down there and they can pay the tax on it. Let me run through the next topic is just the formation documents and kind of some formation matters. One important thing, if I can put a plug in for my friends, the accountants out there, is that a very important thing for a new corporation or a new startup to have is an accountant. Accountants, a lawyer, they'll put together the incorporation papers, give you some good advice, tell you how to run it from a corporate standpoint, and then you don't hear from them for a while until they want to do a major transaction, financing, or they get sued. Then you hear back from them. But the accountant is somebody that is going to be involved with you on a yearly basis. Each year, he's going to help you with your books and records, make sure you're getting your income taxes filed, and answering questions in probably a cheaper manner than attorneys can answer those questions. Attorneys don't deal with the main items of, in general, of deduction of what can be deducted and what can't, while accountants do that on a daily basis. So when you have a question, you'd rather call the accountant because it's cheaper than calling the lawyer, because the lawyer will have to turn a lot of times and do a little bit of research, and the accountant can give you an answer probably off the top of his head with regard to those small questions. In terms of the documents, there's ways that you can go out and form your own company and come up with your own documents, and these are the documents you'll need to come up with. Question?
I wasn't quite certain if I missed it, but can you kind of hit on the LLC, limited liability company? That's a hot issue right now.
It is. I went over it just very briefly, but I'll give you I do a lot of limited liability companies, and I do a lot of them for various people. I do a lot of them for corporations that want to go into joint ventures with other corporations. I do a lot of them for real estate ventures. I do some of them for new startup companies. The reason, and they're great. The reason why a lot of people don't use them as much as you would think they would use them out there, because they have there's great tax aspects associated with it. They're kind of like an S corporation, but they have there's a couple other benefits associated with it. In the event that you want to dissolve the limited liability company and get the property out. But the reason why a lot of people don't want to do it, in my example, the carpet cleaning business coming to me, is it's expensive because you can do just about anything. All a limited liability company is a document that's filed with the judge of probate's office, and then it's an agreement among the members on whatever they want to agree on, how they want to run the company. Whether it's going to be manager or member finance. And there's some hidden gotchas in there. And the second reason that I kind of mentioned is a reason why a lot of people are a little bit nervous about going into it when they're going to own it individually, is that it says that that the only time you're liable is your own acts or conduct, but this thing hadn't been tested in courts. It's intended to act like a corporation, and everybody expects it to act like a corporation, but there's some pretty good litigators in the state, and so I get a little bit worried about it sometimes, but just in case some theory comes up. So when I advise somebody on limited liability company, I always kind of state that in there. But probably the main reason is the expense associated with it, because you can file a document and rely on all these default provisions that are included in the Limited Liability Company Act, but there's some hidden things in there that I don't recommend, such as mandatory buyouts in the event of a death of a member of the company. The documents, and I'm running a little low on time, so I'm just going to run through those very briefly, because I definitely want to tell you some ways to reduce your fees. Those documents, I hope to spend a lot more time with these, are the name reservations. You have to obtain a name reservation from the Secretary of State. You have to file what's called articles of incorporation with the probate judge of this county in which you're going to incorporate. There's a code provision that tells you exactly what has got to be placed in those articles. It's the name of the corporation, the name and address of the registered agent, the name and address of the incorporators and the initial directors of the company, the number of shares to be issued, and the purpose of the corporation. Then you have to either have minutes or an action by written consent of the shareholders and the board of directors approving the organization of the company for the directors, electing the officers, and issuing the stock. You also need bylaws of the company. Bylaws of the company basically govern the inner workings of the company. They tell how much notice that you have to give to the individual shareholders in order to hold a meeting. Most of that stuff is taken right out of the Alabama, at least the forms we use are taken out of the Alabama Business Corporation Act and basically mirror that so that you have your own kind of mini code in front of you that if you have a question about how to do something, you can just flip right to it. Other documents is the stock certificate, the S election. The S election is if you want to be an S corporation. That's a simple document that's filed with the Internal Revenue Service. The initial franchise tax form, that's just a tax form that's filed with the Alabama Department of Revenue. The application for employer identification number, the SS4, that's to get your equivalent of a corporate Social Security number. You use it for filing your taxes and whatnot. And then you need to go out and get certain additional state and local business license, tax applications, and other permits, and you just go to the various courthouses wherever you're going to do business and obtain those. Another item that you should consider doing is a shareholders buy-sell agreement. Shareholders buy-sell agreement is a document under which the shareholders agree what happens to the stock in certain events. It is typical for shareholders to agree that if one shareholder wants to sell his stock to somebody else, that shareholder first offer it to the other shareholder or to the other shareholders or to the company, some mechanism there. A lot of times you also see either mandatory or optional buybacks in the event of certain circumstances, such as the death of the shareholder. If I'm going into business with a friend that's in the carpet cleaning business, I probably don't really want to be in business with his children. So if he dies, I'd rather be able to have at least the option to buy him out, maybe not the obligation. And however you want to work that, you can do it. You can fund. If you want to make it mandatory, you can get some insurance to provide the funds to buy that out. You can do a lot of different things in there. That's probably where you get into the main expense in terms of incorporation. In terms of cost of incorporation, you have some fees with Judge of Probate, the Secretary of State, your initial franchise tax fee, you get in your minute book, all that runs a little bit over $200. That's without lawyer fees or anything. When you involve a lawyer, you add a few more $100 depending on how much time it takes, how many meetings, how many questions you have. Some people give you a flat fee, but generally, including all the fees and everything else, incorporation without too much question runs from the range of about $750, maybe $1,000. Sometimes you get up higher, unless you want to do a buy-sell agreement, and the buy-sell agreement is something that just depends on if you know what you really want to do with the corporation, and if you want to do a bunch of odd things and odd transactions, then that can, because lawyers in terms of this field generally bill on a, they may bill you on a flat fee on the incorporation, but when it gets into drafting documents and doing this sort of thing, they go on an hourly basis. And when you're dealing with a lawyer on an hourly basis, let me tell you how to save some legal fees in connection with incorporating a business. Have all the information ready. That's the main thing. Have all the information ready. Probably have it typed up. The more you talk to the lawyer, the more it's going to cost you. So if the lawyer, you're telling the lawyer somebody's name and he realizes there's two ways to spell that name, and he calls you up and you got to get another spelling of the name and then you end up talking about other subjects in terms of the corporation and start asking a bunch of questions that runs the fees up. So get all the names, the addresses, and the number of directors. If you know what they're going to be, you can ask questions when you get there, but if you think you know what they're going to be, put them down. The name, number, and address, and number of shares to be issued to each of the shareholders. The name, address, and position of each officer, and their Social Security numbers, because you need, for certain documents, you need their Social Security number. The purpose of the corporation, the name of the corporation. Provide a couple options. In order, you have to reserve the name. The Secretary of State won't give you a name if it's deceptively similar to another name of a corporation. So give a couple alternatives so they don't have to pick up the phone and call you back, and you have to sit on the phone and kind of come up with another name. So if you can give 3 or 4 alternatives, they can call the Secretary of State's office and just hit them one after another until they get a good name. Other information is They need the closing month of your accounting year, the first date, wages paid, highest number of employees in the next 12 months. Whether you want to do an S corporation or C corporation, there should be some assistance here, but you may want to talk to your accountant if you have one and maybe get some of his advice. And the terms of the buy-sell, if you want to do that. At this point, I wanted to, I guess it's the end of my time, and I appreciate, there's a couple other topics that I wanted to get to, and I tried to talk as fast as I can, but I was trying to shove about 4 years worth of, or four semesters worth of law school into 30 minutes, but I hope I've enlightened you a little bit. You have a question? The reason, it varies. There's a number of reasons. Probably the main reason, and big companies really like to incorporate in Delaware, is there's a whole lot of law up there. Our Alabama Supreme Court really doesn't like to deal a whole lot, or hasn't in the past, with the nuances of the Corporate Act. Delaware, a ton of corporations since the turn of the century have been incorporating up there. They have a lot of litigation up there. There's a lot of cases out there, a lot of precedent for if you want to do an odd transaction, you can probably go to the books, the Delaware Code, and find an annotation and find some cases that are almost exactly like the type of transaction you want to do. That's probably the main reason they want to. Also, in terms of big corporations, you generally look to the law of the state of incorporation to tell the relationship between the shareholders, board of directors, and officers. And Delaware is very kind to the board of directors and the board of directors and the officers of companies. So generally, publicly traded companies would rather be up there. So if they have some problem with some breach of a duty or some argument by the shareholders that they didn't think they did something right, that there's a lot of law that's very beneficial to those individuals, to the board, the people running the company. Thank you.
Thank you, Hall. That was very informative. Alan and I, neither one realized that you had to have a shareholders meeting once a year. Is that what you said? Yeah, we didn't know that. Next, it is my honor to introduce Alan Brinkley, and I know you've gotten to know Alan a little bit from being here with him. How many classes have you had so far? 10? Well, you probably know him as good as I do then. But he's a longtime buddy of mine and is a super lawyer. Alan is the owner of probably the top 3 judgments in this county. I know the top 2. He is a hard worker. He won't back down. He is the most optimistic human being I have ever known. His wife's sitting back here, and she knows that's the truth. Alan and I have handled some cases together where we were on the same side. And we had one lawyer who was absolutely the worst pessimist I've ever seen, and I had Alan. And so I was kind of in between calming Alan down and convincing this other lawyer we were going to win. Alan got his law degree from the University of Alabama and was educated here locally. And of course, his family lives here, and I'm sure a lot of you know some of his family. He's married to Melissa Crute and has been married for the last 26 years. He has a son, John, and a daughter, Becca, who are both at the University of Alabama. Since y'all know Alan as well as you do, and this is a little bit, I'm taking a lot of chance here because I think he's going to introduce me in a little while. But I asked my office to call and get Alan's resume, and they sent it over today, and I looked at it, and it says that Alan grew up in Huntsville, attended Samford University, the University of Alabama in Huntsville, and the University of Alabama in Tuscaloosa. And I said, he went to Samford. They either sent him home or Mom and Daddy had to go get him. They sent him out to UAH, made him stay out there until he talked them into letting him go to Tuscaloosa. Now, I haven't asked Alan, but I'm betting you that's the way that went down. But anyway, I love him to death, and if I got a problem, Alan Brinkley is my lawyer. Alan Brinkley.
Thank you, ladies and gentlemen. As George said, first of all, I do want to introduce my wife, Melissa. She's the one back there hiding behind the light switch. And over here in the brown is Mim Bryant, Hall's wife, and in the words of Winston Churchill, they are the ones who must be obeyed. So they're here tonight. Hall talked a little bit about how to incorporate, how to put a corporation together. What I'm going to do in the next few minutes is talk to you about how to take one apart. Now, it's pretty easy if you work at it, maybe if you make it your life's work. What I'm going to try to explain to you is what I have learned over the last 22 years in regard to suing corporations and representing corporations who have been sued. It seems that approximately maybe 60% or 70% of the defendants in a lawsuit are corporations. So you must recognize and deal with that form of entity. Now, we are the loyal opposition, the people who sue the lawyers, the corporations, but don't get me wrong, the corporate form is a great form, and it's sort of like our American system of government. Till you think of something better, don't criticize it too much. But in going through and preparing for this talk tonight, I will tell you what I did. I sat down and went through the Alabama Digest and reviewed approximately 1,000 cases, 2,000 cases, which are all of the litigation cases that there have been in Alabama since 1819. And what I came up with is that there are about 42 consistent rules that you need to know. I've written them down in the outline. I'll get to them in a minute. But first, I want to talk to you about the practical considerations of a corporation. One I will mention, Hall mentioned that every corporation must meet once a year. And I will tell you that, for example, my partner Chestnut, they have a family corporation over here in Galesville, Alabama, and they meet once a year. And in their corporate bylaws it says, and we shall meet on the fourth Thursday of every November. Think about that. Isn't that neat? And they have always met, so they're legal. Now, in the words of Joe Barry, if you're a trial lawyer, never give a lecture on tactics, trial tactics in your hometown. Rule 1. Rule 2 is that in regard to the corporate structure, remember that corporations, you should not treat them any differently than an individual. And don't come to trial talking to the jury about the corporation as if there's some separate, ugly type of animal, or you'll get your case reversed. For example, there's an excellent lawyer down in Talladega named Betty Love, and here's what she said one time, and it's the gospel truth. They were in a great swearing match in the middle of her trial, and she said, this corporation, in closing argument, she says, it doesn't have a heart, it doesn't have a soul, it has no blood running through its veins, they're not going to heaven or hell, and you're going to believe them over us? Well, the Supreme Court reversed that case and said, Betty, you overdid it a little bit. I mean, the trial court has a lot of discretion, but in that case they said you did specifically separate the wheat from the chaff there. You did make the corporation stand out to be something that it's not. The next rule is that never talk about the wealth of a corporation. Never talk about the wealth of any party unless it is just absolutely the pivotal issue in a case. That is taboo. Have you ever noticed that in every political case, every political situation, the guy who's losing by the end of the election, he always talks about how poor he was and grew up in the basement of a house in lower Alabama or upper Kansas or somewhere. You know that because the poverty, the rich and poor thing, it is something that just gets us all right here, doesn't it? I think it's worse than the black-white or the man-woman bias. The rich-poor is the worst. And don't ever talk about a corporation's wealth or you will be reversed so fast it'll make your head spin. I learned this heart and soul rule because I used those 3 words once myself in a case, and I thought I would never get out of that jam for using those words in a corporation case. Now, if you take a case against the obvious, here are some rules you need to know. I'm going to tell you the rules that I am going to also lecture lawyers in December of this year, trial lawyers, on how to sue a corporation. So if you want to know the level that you're getting it on, this is exactly what I'm going to tell those lawyers. Looking around the room, I know that you doctors and engineers are a lot smarter than all those lawyers. And I can assure you that you can probably handle this sophisticated material. Now, listen to me. When you take a case against a corporation, don't ignore the obvious. Use common sense. Don't get so confused with what your client's telling you or what you think is wrong with you that you can't walk around the block, take a deep breath of fresh air and say, does it make sense? Will it make sense when I get up in the morning? Don't file the suit half-cocked. Don't do something that is so beyond common sense and off on the tangent that you're going to lose. Don't think just because it's a rich bank or insurance company that they're not intelligent enough to bring the jury down to reality so that you will lose your case if you're not careful and you're going to be embarrassed. Read books like The Art of War by one great Chinese writer about 2,000 years ago, and it will tell you such things that are philosophically right down the corporate law avenue, and I'll come back to that in a minute. The next question, do you sue? You sue only if you have a defendant who has money or insurance. We are not in the business of making a point. There is a standard of exchange in America, and it's called money, and the jury sets that standard. I'm very curious as to find out what the lives of the two people in the O.J. Simpson are worth, because that might set the record. I don't know. But that is, but I will tell you that we in America, in our jury system, money is the standard. And I'm never going to take a case for principle, just to make a point. I've heard people do it in slander cases, but I'll tell you, in a slander case, half the people are going to believe it, the other half won't, and all you're going to do is reinforce the lie that was told about you. So the rule in slander cases is sticks and stones will break my bones, but words will never hurt. That's the rule. There are some defamation cases that have been taken. The largest ever one in this North Alabama area was a $250,000 verdict that we got about 10 years ago, I guess. My law firm did, and it was eventually reversed by the Supreme Court of Alabama. Again, the basic theory, as I understood it, was sticks and stones will break your bones. Think about that. Who do you sue? You sue either a corporation, a partnership, or an individual, because those are the only types of entities that exist. Now, Hall Bryant has mentioned to you that there are certain various types of partnerships, but still partnerships, corporations, or individuals. Next, avoid suing the individuals, because the personal sympathy involved in suing the truck driver or the nurse will give you more problem than you really want. Don't sue the individual if you can avoid it. Sue the corporation because they don't have a heart and they don't have a soul. Just don't say it. Now, what are your chances of winning? Every case I get, everybody says, well, do we have an 80-20 case? Do we have a 70-30, 90-10? Look, those numbers are for insurance companies and for my bookie. Your chances are 50-50. This is the only case you got, and you're either going to win it or you're going to lose it. But don't sit in here and go through this statistically 80% of the people win. That ain't got nothing to do with your lawsuit. You're going to either win or you're going to either lose, and that's that. Now, on the defendant's side, the corporations actually run those statistics and they make studies, but that hasn't got anything to do with suing a corporation. Now, be sure when you file a lawsuit that it's a pretty lawsuit, that it looks good, that you've had somebody read it and correct the errors and make it make sense. Because you're going to say some pretty ugly things to them, and they're going to pass it around the corporation, and they're going to talk, and they'll say, look here, he can't even spell. And so in that standard, that's very important. We all know that the people in school that make the best grades are those who can write well because it looks good. And that's a standard, isn't it? Write your lawsuit well, make it pretty, make it make sense, make it so that when they get a hold of it, it creates fear in the minds of the defendant, and they completely understand what you're talking about. Also, make sure when you serve it that you don't serve the man who did it. We've always heard of people who like to serve the others on Christmas Eve and make sure that the guy who did them wrong, they put it in his face. That's stupid. You give it to the president of the company who'd had nothing to do with the bad act. And that way he can come, and if there is to be a settlement, if there is to be a correction, if there is to be a mediation, then he who did it ain't going to try to cover it up for the next year and a half and make your life miserable. I've had many cases that I've filed, and I've written it so plainly that the person in charge came and they said, "Oh my God, we had no idea. What do you want?" It's not that I'm so smart. It's just some teacher told me that when I was in law school. And isn't that so simple? Isn't that common sense? Make it pretty. Make it literate. Make it right. Now, when you're in the lawsuit, there are a few things that are so obvious to you that are exactly backwards under the law. Now, you can't introduce into evidence at trial the report that he came back to his company and said, "Oh my God, I ran over Alan's wife and children and I was drunk and this and that, and I'm sorry, here's the report to my boss." That report is a secret. It's privileged. Otherwise, nobody would ever turn themselves in ever, or they would always write a self-serving report. That report is privileged. Now, what about the accident report to the police officer? It also is not admissible. Also, what about the unemployment compensation hearing report? It's not admissible either. Those three things are not admissible. Why? Because there are other interests that our laws have decided that need to be protected, and that is that these particular proceedings and reports need to be made, and they need to be made truthfully without fear of having to drag them into a courtroom. Now, at trial, you would say, "Well, goodness gracious, I caught him breaking the company policy. He broke the company rule, therefore I win." Right? Wrong. Just because, now you can introduce that company rule, whatever it is that he broke, but that does not automatically mean that you win if you're the plaintiff. What it means is that's evidence of the fact that he did not meet the standard of the care, but that doesn't mean you automatically win the case. Now, when you file suit, the first thing you should do after you write up your lawsuit is write the discovery requests. While you're thinking about it, write down everything that you ever wanted them to produce for you. That's a very important item. Make sure you do it. And set the deposition of the bad guy, the guy who did it. Set it 46 days from now, which is the earliest you can get a hold of him. Because generally in a case, there's usually not a corporate conspiracy that you're going to find. Usually there's going to be one bad guy who did it and said wrong, and what you should do is get a hold of him early and tear his heart out. That's what you should do. Catch him in the lies before you get him, before he gets his story straight, and you will find that your whole lawsuit will build upon that. Remember that. That's what you should do. Try to do it in every case. Sometimes it's impossible. Sometimes it's impossible because those that really did it have already been fired or are no longer employed. But if he's still working there, go get him. And go get him in 46 days because that's the earliest you can get him. Now, the first thing that will happen when the defendant's lawyer shows up is that he is entirely too busy for your lawsuit. I'm sorry, he cannot get a hold of this case until he's got depositions until this and that and on and on. And how about maybe April or May of next year? We'll sit down and try to view it. First thing you do is tell them straight to if they're really serious about insisting on such a position, go see the judge. And I know Judge Snodgrass looked at one lawyer who was giving me down the road on that same party line, and he said, you know, having too much business and making too much money into the law is really not a defense to not giving a deposition within 46 days. He said, I think you need to go on over to Alan's office and bring your guy over there and y'all give him a deposition. But if you got to push it, do it. But they will never, ever, ever cooperate with you. And they will do it from the beginning. And if the plaintiff's lawyer is dumb enough or weak enough is a better word, to follow along, so be it. Keep control of your lawsuit. The timetable is yours. Deposition in 46 days, production in 60 days, this and that, 90 days after that will be for trial in 11 months in Huntsville. That's the usual timetable. Now, watch the defendant splinter. They will hire brilliant lawyers and many lawyers. They will hire, usually a factory of lawyers like Hall Bryant's law firm. And there will be, like Jerry Spence says, a stable of good horses ready to run you down and drive you crazy. And the fact is what I have noticed is that in many cases, they hire too many chiefs and not enough Indians. And there's an old maxim that says one bad general is generally better than two good ones, and it's really true in lawsuits, is that the oxen start pulling in different direction and they go nowhere. But you get a smart corporation that gets one lawyer, and so that the president will come down and look at him and say, it's your fault, it's your responsibility to make sure we win this lawsuit or you cut our losses. And I'm going to answer, I want to talk to you in about a year or about 11 months. And I don't want to talk to these 15 other underlings or assistants or brilliant men for hire that you've employed. I want you to answer to me. And if you have a corporation, do that. And I hate to tell you this, but I've won many lawsuits that I shouldn't have won simply because the defense divided, and I picked them off one by one. Now, when we defend corporations, we're so small that we have to have one person, see? But if you have the luxury of so many, sometimes you get to be like that Persian army when they fought the Greeks. Think about that. Now, they will paper you to death, but when you get to the trial, it's one-on-one. It's one-on-one. They can only have one lawyer speak at a time, and you can beat him there. If you can survive the paperwork nightmare for the year before trial, you can beat him one-on-one, as long as you're brave. Now, when you're at the trial, I'll give you a few trial rules. Number one, be brave. Number two, be brave. And number three, it's the same. Tell the truth. And I don't care how many times your client has told his story. He's been to the Board of Adjustment. He's been to the Zoning Commission. He's told it to the City Council. He's told it to a lower court. They've been on appeal. He's told it to the appellate court. He's told it in every smoke-filled room. But then when he shows up right here, he's got the chance to tell it one time, and they're not going to know all the other times it's been told, unless he's inconsistent. But tell it one time, tell the truth, and if you're a lawyer, don't overdo it with him and rehearse him, because sometimes there's a fine line between rehearsing him and convincing him to lie. Tell him to tell the truth when you begin, tell him to tell the truth when you end. Always tell the truth. What's wrong with the truth? Or as Pilate said, what is truth? Now, also when you're in the jury trial, talk their language. Don't talk up, don't talk down, talk the language. Talk the language. Don't talk to the French in Spanish. Talk to the Huntsville jury like this. Explain and please understand, we put the man on the moon, didn't we? Can't we just protect some little old lady out here in Owens Crossroads? Can't we? Because we put the man on the moon. Because we did. Now, do y'all understand that? Yes, you do. Because there are many people in here that did. But understand that. Talk the jury's language and put it in very simple English. What I'm going to go through in the next just couple of minutes are the 2,000 cases that I reviewed, which are all the corporate rules in Alabama since 1819, and I will tell you that I can combine them into about 40 different statements. Number one, the state of your incorporation controls. Shareholders are not tenants in common. You don't need a corporate seal. The corporate board acts as a body. The president has no greater power than the others. The majority rules, but the majority cannot oppress. The shareholder cannot remove property or papers from the premises just because he's a shareholder. Also, just because a shareholder is obnoxious, that conduct does not disqualify that shareholder from having rights. Also, the majority must be fair, and they cannot write up legal papers that make what they say or justify what they say as being right. I've been in so many lawsuits where the board of directors says, we completely authorize and approve everything we did. That piece of paper is not worth what it's written on. Also, a majority cannot divert a corporate opportunity. You can't use the telephones, the yellow page listing, the corporate employees, on and on, for your own benefit. You cannot do it. Also remember that commingling funds is not necessarily always wrong, but it's a dangerous thing to do. Now, attorney's fees, you can get attorney's fees sometimes you can't. Also, if you're a parent corporation and you have complete control of a lesser corporation, then I will tell you this, you may be exposing yourself. Now, everybody wants to know, well, what is my liability if I'm a corporate director? Well, tax liability, you're going to be liable for those taxes. If you fraudulent deed away property, you will be liable. You're not under workers' compensation theories, you're liable only if you willfully injure an employee. Furthermore, if you act in good faith and you are a director, you can be excused from liability. Now, your directors and officers are trustees, but then there's language which says they are not trustees or quasi-trustees. Furthermore, they may forfeit their compensation if they misbehave during their tenure in office. Now, a corporate employee, as Mr. Bryant said, may be liable individually for what he does, his actual acts. Remember that. The corporate form does not protect you just because you did it while on company time. Now, in closing arguments against corporations, corporations will always say, we always do it this way. We always run red lights. That's just the way it is. And in the total scheme of everything, it doesn't matter. Isn't that what they always say? Well, I'll tell you this, that if you get to the end of your case and you have survived the trial, and you have been able to put on your evidence and the judge has not thrown you out, you need to have something clever to say in closing. I like this one. One day an old man was walking on the beach. It was low tide. The sand was littered with thousands of little stranded starfish. The water had come up and left them behind. The man found himself he was very careful to step over the little starfish because they were still alive. He considered picking up some of them, but there were so many of them. He said, well, maybe I could throw some back and they could resume their lives. And he knew that if they stayed in the sand that they would die. He reasoned he couldn't possibly help all of them. So he chose not to help any of them. That's just nature's way, he said, and he kept walking down the beach. Soon he came up to a little boy about 10 years old, and the little boy was frantically throwing starfish, one starfish after another, back into the water. And the old man stopped the little boy. He said, little boy, what are you doing? He said, little boy said, well, I'm saving the starfish. He said, son, you can't. You're wasting your time. Why are you trying to save all these starfish? What difference does it make? And the little boy stopped for a few seconds, and he bent down and he grabbed another starfish. And he says, it makes a difference to this one. And he threw it back in. And in this case, it makes a difference to these people who have come to our system of justice and have asked you for their help. Think about it. Thank you very much.
To the extent that this educational program could be construed as an advertisement for any member of the faculty, the following statement is required by the bar. There is no representation made that the quality of legal services to be performed is greater than that of the services performed by any other lawyers.